Hello, everyone. Thanks for attending. So this is part of our private international module. Private international law module, to be more specific. Professor Lombardi and I have been co-teaching in this module, both from the perspective as well in the European Union perspective. And thank you, Dr. Michael Stuerner, you will cover today provisional and protective measures, evidence gathering when we have proceedings. I would also like to thank our Erasmus partners, and since we're doing that along with the EU Fund, EN Force. And now I will give the floor to Professor Lombardi to give an introduction about our guest lecture. Thank you.
Thank you, Maria. Thank you, Michael, or Michael, as I call you always. So I would like to welcome everyone to the guest lecture series in private international law. As Maria was saying, that's the first one of the lecture that we'll have. And I would like to thank a lot my dear friend, Michael Stuerner, Professor Stuerner, who is in contact with us from Constance. I will give a very short introduction to his lecture, and then I'll give the floor to him because we have to recover the little bit of time that we lost so far. So Professor Stuerner studied law at the University of Würzburg and as well in Geneva and Munich. In 2000, he received his Magister Juris degree from Lincoln College, so from the University of Oxford. And 2 years later, during his legal clerkship, he did his doctorate under Dagmar Köster-Waldtigen in Munich with a comparative law thesis on civil procedural law. After the second state examination, Professor Stuerner initially worked as a lawyer in Munich and Cologne from 2004 to 2006, before dedicating himself entirely to his academic career. Since 2004, he has been a research assistant to Professor Heinz-Peter Mansell in Cologne. There, he habilitated in 2009 and acquired the venia legendi for the subjects civil law, civil procedure law, international private law, comparative law, and European private law. In the 2009 summer semester, Professor Stuerner took over a professorship at LMU Munich before accepting a professorship in civil law, international private law, and comparative law at the University of Frankfurt-Oder in 2009-10 winter semester. He remained there until 2012, when he accepted an offer from the University of Constance for the chair in civil law, international private and procedural law, and comparative law, which he has held ever since. He has also been a judge at the Karlsruhe Higher Regional Court since 2013. Among the many publications, very interesting and enriching, that he did, I would like just to mention a few of them, especially the monograph was titled, the first one is The Challenge of Civil Judgments, a Functional Study of Legal Remedies in Germany and English Law. Then, the principle of proportionality in contract on the doctrine of a limitation of contractual rights and obligation inherent in private law. And in addition, he published numerous essays in specialist journals and celebratory contributions, such as the arbitration agreement stated for contractual dispute in IPRR in 2014. And he is co-editor in Jura and Journal for Private Law of the European Union. So just with this short bio, you can easily understand the level of your host, of our guest. And what is always impressing me is the wide knowledge of the legal regime, the legal rules, and the legal system that Professor Stuerner has. And is astonishing me always, because he's not just an appearance, he knows them in a very deep way. And today we will have an essay of that. So I don't want to keep the floor, because I'm very happy to hear you, Michael. And I leave you the floor. Thank you very much, Michael.
Thank you so much, Professor Lombardi. Grazie, Ettore, for this kind introduction. I'm happy to appear as a guest lecturer in this course. And I gather you are an international cohort of students striving to get into the details of private international law. My task today is to share with you the knowledge I have on provisional and protective measures, with a particular focus on evidence gathering. And I was free enough to, include some kind of repetition, recap vis-à-vis the Brussels 1 bis regulation. I gather you have done that already a few weeks ago, but since it's vital to get back to that, I will include a short, 20 minutes or so on the Brussels regime. But first of all, on our topic today, and I realize I can even go forward myself. That's great. So I'm the master of the proceedings here, which is good. I'm used to that since, as Professor Lombardi told you, I'm a judge also at a higher regional court in Karlsruhe, Germany. And so I see things always from two angles, from the practical one and from the theoretical one, which helps me a great deal in delimiting any ideas I might have from an academic view. I always ask myself, what would my colleagues at the court say to these ideas? Would they just nod, or would they say, what is that? So it's quite healthy to have such kind of peers to keep you from fantasizing too much. Right, so provisional and protective measures, that's the topic here. And at the outset, I think we should discuss why we had that. Why is that a topic in such a course on civil, private international law in civil cases? And the outset is, I think, the basic right of access to justice. And I'm daring to ask you all, and I'm not sure if you are willing to answer at this stage, where does this right of access to justice stem from? What is the legal basis for the right of access to justice? So I invite you to share your views on this, or you can write it in the chat, if there is a chat with MS Teams. I'm not even sure.
Yes, there is a chat.
There is a chat.
Yes.
Now let me see if I can open this chat. Where is it?
Can you see the bubble on top of your screen? Maybe that you don't have access to it though, via the web browser.
No, Stephanie, we don't have access.
Yeah.
Okay.
We can see it though. We can monitor the chat. Maria can monitor the chat.
Okay, but I invite students just to turn on the microphones and just speak. What is the legal basis of access to justice? I mean, there are many of them. So I just ask you for an example or two. I guess every jurisdiction has some kind of, guarantee for access to justice. And I would be happy to have any of these bases.
As well, in terms of comparative terms, could be very interesting.
You also have non-students here. We have professionals as well.
Oh, very good.
Very
So,
good.
Joya, who is one of our second year students, mentioned Magna Carta.
Okay.
Cool.
You mean the English one, 1215, right? You mean that one?
Yeah, I think that's what you meant, yeah.
Very nice. So it's quite old. And in more recent times, because the Magna Carta, if at all, I believe it's still in force actually, but if at all, it's in force in England and Wales and not in the rest of the world, as far as I'm concerned. How about other bases? Well, it's not that easy. If I think of the German constitution, there is no explicit right of access to justice, in civil cases at least. And if you think of European conventions and instruments, the first thing that springs to mind is the right to fair trial, Article 6 of the European Convention on Human Rights. This would be the most explicit basis for the access to justice right that we can think of. The Strasbourg court has always included the right of access to justice into the right to a fair trial. So that's pretty basic. So you have to have an opportunity to go to a court with any plea you might have. And the combination with the second sentence on my slide, justice delayed is justice denied, then adds up to a plea for protection of those interim interests. Justice delayed is justice denied. That's a legal saying, and it's not quite clear where it comes from, but it's pretty basic and pretty universal. If you get a judgment from now on in 10 years, it's totally useless for you if the interest has ceased to exist in the meantime. So you need a speedy, relatively speedy judgment to have your rights protected. And this means that courts must provide for remedies for urgent cases also. There are cases where you need judgment within a couple of days or even hours. And this is why we have these provisional and protective measures. That's universally accepted. The problem is, however, that courts need to strike a balance between the interest of claimants who want to apply for such measures and defendants who want a fair trial, a trial which grants a right to be heard, for instance, and a right to protect their interests also. So the main principle is the principle of proportionality, that is to strike a balance between the interests of both parties. And the leitmotif, so to say, with interim remedies would be to ask yourself where not granting the remedy would do greater harm than to grant remedy without justification. So you must assess the risk to be wrong with the interim remedy. And if this risk is low enough and the interest at stake of the claimant are higher, then the court must grant this remedy. We can broadly distinguish two categories of interim remedies, that is provisional measures and protective measures. And you always have this dual notion of provisional and protective measures. It's maybe better to refer to provisional including protective measures, because I would think provisional measures is the more broader term, the term encompassing also protective measures. And in some versions of the Brussels BIS regulation, you would have provisional including protective measures. In others, you would have provisional and protective measures. That's not a great difference, but I would say any protective measure is also provisional in nature. So this is the broader term. Now, to give an example of a rule, and I was hesitant which jurisdiction to choose, which legal order to choose. I chose none of them. I chose model rules of civil procedure of the European Law Institute, ELI, and UNIDROIT. So this was a large project which started in 2014 and resulted in these model rules. And you see, it was a book published with OUP. I think it was issued in 2021, but the rules were adopted in 2020. And they are a result of a comparative work of lawyers from all over Europe. So it consists pretty much the state of the art concerning procedural law in Europe. And these model rules contain a section on provisional and protective measures. And you see the definition here in Rule 184. And it says pretty basic, a provisional or protective measure is any temporary order that has one or more of the following functions. And then comes the enumeration of 4 different types of these interim measures. But the main point is it is temporary. So it's not something to settle the claim once and forever, but only in an interim way. And so in litera A, you see it is a measure which has the function to ensure or promote effective enforcement of final decisions concerning the substance of the proceedings. So you get your judgment, you want to enforce it, but then the assets are being dissipated. The money is gone, there's nothing to enforce into. And this is why you need protective measures. Letter B. Measures which have the function to preserve the opportunity for a complete and satisfactory determination of the proceedings, including securing evidence relevant to the merits or preventing its destruction or concealment. So this is a different stage of the proceedings. You don't have a judgment, but you want it, and you can't get your judgment because the opponent is dissipating assets or documents which are relevant for the proceedings. Now you can ask the court to preserve these documents. Letter C, to preserve the existence and value of goods or other assets which form or will form the subject matter of proceedings. Similar situation, you need something, a good or an asset, which is at the heart of the proceedings. So you need it to prove your case, and this is why you can ask for a provisional or protective measure to prevent it from being destroyed or whatever. And then letter D, to prevent harm from being suffered, to prevent further harm pending final judgment. So you have 4 categories broadly, and this represents the state of the art in European civil procedure. I think any of your civil systems from the countries where you're from will have similar types of possibilities. Now, if you look at the comments to these model rules, they have a different approach, or an approach which reflects a different categorization. And this rule, which I just cited, is broken down to 3 categories: conservatory or preservation measures, regulatory measures, and anticipatory measures. The bottom line of all this is anything that the parties may ask, or a potential claimant may ask, the court must grant if the proportionality issue is settled. So if the interest of the claimant is greater than the potential loss of the defendant. Now, I see a raised hand. Is that a question?
Yes, sorry, Michael. I wasn't sure if you could see the chat, but based on the previous slide, I think it was the 3rd point. Nicolas mentioned that it reminded him of freezing orders, which actually we have measures under EU law about assets not being able to be moved to another jurisdiction. So I think that could serve very, very well as an example of protective measures in one way or another.
Yes. I'll come back to freezing orders at the end of this lecture. So the old Mariva injunction from United Kingdom, this is a perfect example of, you freeze assets in order for them not to be dissipated before you get hold of them. I see that there is something in the chat, but I can't see the chat. I don't know how to do that. But it's fine if you raise your hand or just speak, and then we have the questions right away. Okay, so just to make clear that there is a whole range of different measures to be applied, to be issued, and the court must decide which one is correct and which one is proportionate. Now, looking at the international dimension of the whole thing, typically in a globalized economy, we are dealing with cross-border cases, and in cross-border situations, time is even more of the essence, and it's even more difficult to get hold of assets when you want to enforce your judgments, when the assets are being hidden in a different jurisdiction, because the sovereignty of a state is usually stopping at the borders. So you cannot ask your own state to enforce a judgment outside the jurisdiction. You have to go to a different jurisdiction, and this is where the cross-border dimension comes in. So these bullet points are some of the problems which arise in the context of international provisional and protective measures. So the first would be to describe the special interest we have in the judicial area of the European Union. So the interest we have to have a smoother regime inside the EU as opposed to third states. So I'll briefly deal with judicial cooperation first. We'll then move on to jurisdiction issues. So which courts do have jurisdiction for provisional and protective measures? And this is the recap I told you I was going to do with you. So there are different heads of jurisdiction, and we're going to clarify which of them are used or may be used for provisional and protective measures. We'll also speak about lease pendants, so parallel actions, and we'll speak about recognition and enforcement of decisions. And also the Brussels 1 bis regulation has the rules. We'll then move on in the last part to the preservation of assets under the account preservation regulation, EAPO regulation, which is relatively new and sadly not used much so far, at least in my country. It's very depressing, so to say, to see this relatively innovative regulation being, totally silent. Nobody applies for these orders so far, or very few orders are issued by German courts. And lastly, we'll have a brief look on the taking of evidence. I do address the issue of taking of evidence while speaking, but the last slide will be devoted to the cross-border taking of evidence in Europe, the European Union. And I gather I can speak until 4 o'clock, right? Or 5 o'clock in Cyprus time. Or do I have to stop early?
If we can have maybe a 15-minute Q&A session, that would be great.
Yes,
if
of
you,
course. Of course.
Yeah,
Yes,
okay.
of course. Yeah.
Absolutely, thanks.
So Q&A, I would say anytime you want, and I reserve 15 minutes at the end of the session. Okay?
Thank you.
Right. Judicial cooperation in the member states. So the European Union is a special area for the law and for court proceedings insofar as there are common rules. And the competence for these common rules stems from Article 81 of the Treaty of the Functioning of the European Union. There is a competence for measures for the approximation of laws of the member states in civil matters having cross-border implications. This is a pretty important rule, and it's a basic one. And we have had rules, pertinent rules, for a very long time. So even though this Article 81 came into existence only 20 years ago, a bit more than 20 years ago, we've had rules on jurisdiction and cooperation in civil and commercial matters already long time before. But the first rule in that respect was the Brussels Convention from 1968. And it roughly survived over these all these decades and is now to be found in the Brussels 1 bis regulation. So it's the, if you will, the third evolutionary step from the Brussels Convention 1968 to the Brussels regulation, and then now the Brussels 1 bis regulation. So you see, it's pretty important. The member states then in the 1960s could not rely on the competence of the European community as it then was, but they had to conclude a contract between themselves under public international law. And that's what they did. And they concluded a convention on judicial cooperation, jurisdiction, and recognition and enforcement of judgments in the European community. And it was quite successful in the sense that it was accepted in practice and it was deemed to be good and adequate for the needs of the international economic exchange in the member states. So mostly Article 81 refers to procedural law, jurisdictional issues, or certain ways to conclude proceedings. So there is a small claims proceedings, or there is a enforcement proceedings under Article 81. And there is also conflict of laws competence, so the Rome regulations, which you, I'm sure, are familiar with, and the successions regulation, the maintenance regulation, they all are based on Article 81 of the TFEU. The main purpose of Article 81 is, of course, to facilitate the functioning of conduct civil proceedings with cross-border implications. And this is, of course, something related to the internal market. So it's not a direct effect, but an indirect effect. It doesn't facilitate the exchange of goods or persons inside the union to have a cooperation of the judiciary, but an indirect one. So if you conclude a contract with someone and you know there is a system of enforcement of judgments, if the other party doesn't pay, then you will probably have more confidence in concluding this contract, and economy will strive. This is the rationale behind it. And what is reflected in the Brussels 1 bis regulation is a basic principle that is that of mutual recognition of judicial decisions and indeed judgments. So it's a judicial area, and one judgment issued by a court in one member state will be recognized and enforced by any other member state, save for special circumstances. So there is a free circulation in principle of decisions, judicial decisions, in all of Europe. This is pretty advanced. As I said a couple of minutes ago, usually state sovereignty ends at the border. So if an Italian court issues a judgment, Austria will not be in a position to enforce it without a special proceedings at the outset. They will say, well, we have our own courts, and it's a sovereign act of a foreign state, and that's that. On the basis of the Brussels regime, however, the judgment of this court will be enforced in Austria, in France, and in Ireland, and it will only not be enforced if there are compelling reasons not to do it. So it's pretty, if you look at the global arena, it's pretty advanced to have such kind of confidence. And just the last word on that, it's under dispute to have it so dogmatic, I would just say. It's a dogma in Europe. We do have mutual trust, even though there is reason not to have trust in some respect. So we are totally different judicial systems, and to say we do have trust no matter what is a bit over the top. So at some point you could think it's a bit a theory rather than a real trust. So it's a fiction, but it's still the basis of all the European judicial area, mutual trust, and everything is based on this trust. Well, one thing was wrong on this slide, and of course it's this. So this pretty island in the northwest of Europe decided to leave the European Union, sadly, as you know. So the Brexit referendum in June 2016 was the start. I would say it was rather an accident than any conscious act. And then the UK entered the slippery slope, and the result is known to you all. After this referendum and the invocation of Article 50, so the procedure to leave, there was a departure, the decision on departing, which took place on January 31st, 2020. And there was a regulation on to extend the single market rules until the end of 2020. And on 24th December of 2020, a trade and cooperation agreement was concluded between the EU and the UK. And those talks were quite nasty, I would say. So it was a difficult negotiation. But finally, the two parties agreed on this agreement. It entered into force, but it does not contain any rules on judicial cooperation, which means that from the time when the UK finally left, the UK is a third state from the perspective of the European Union. Now, there's a question. Roman.
Yeah, sorry, I wanted to ask, since you mentioned that your judicial system is different, I wanted to make clear why it's so different.
Well, if you look at the judicial systems, if you look at the court structure, there is absolutely no uniformity in Europe. We have different traditions. We have a common law tradition. So Ireland, the UK, Cyprus is also, and Malta is also roughly a common law country. We've got the French tradition. So France, Spain, Italy, they would be in the French tradition, and the Germanic tradition, so Austria, Germany, and so forth, the Nordic tradition, and there is no uniform approach to civil procedure. And to say, nevertheless, we trust all those systems, even though they are different, that is quite something. That was my point. And, you know, it boils down to hard cases, of course, but if there is something we don't know in a different judicial context, and we need to accept it, that's hard. If there is a possibility in a foreign jurisdiction to apply for a freezing injunction, like the Mariba injunction in the UK, it was totally alien to the continental systems 20 years ago. And still, in the first place, they were asked to accept it. It's a very general point. We do have much in common, and with Article 81 working and more regulations coming up, we do have more common features, of course. There is harmonization and approximation of laws also in civil procedure, but still it's different. The systems have different patterns and work differently, and so to say we trust nevertheless is quite something to say. That was my point. Right. So Brexit took effect, and it took effect without any specific rules on judicial cooperation. That means that judgments by English courts can no longer be automatically enforced in the European Union. The UK tried to enter the Lugano Convention, which is a convention designed along the lines of the Brussels regime, Brussels I regime, and they applied for a membership in this Lugano Convention, but the EU refused. And it was, I would say, an act of stubbornness. You left, so we don't let you join. A bit silly, I would say. It would have been good to have the UK inside the Lugano system, but, well, you can call it retaliation or whatever, vendetta. You left, so we don't want you in any of these integration systems. That's what happened. So it means that the UK is totally outside when it comes to judicial cooperation. Right, one of the basic notions is jurisdiction. And with jurisdiction comes what we call choice of forum. So jurisdiction is one thing, and choice of forum is possibility to have your word when it comes to jurisdiction as the parties. The jurisdiction can be defined as the allocation of competences. And at the outset, this is for every state to decide for the state. There is, at the outset, at least, no global system to delimit jurisdiction of courts. Public international law does not say these are basic principles for jurisdiction. At least this is one opinion, I think the preferable opinion. So it's up to each state to define the limits of jurisdiction of their own state courts. And the view on where are the limits of jurisdiction, of course, are different. If you look at the US, for instance, you've got something, at least the continental lawyers in Europe call long arms jurisdiction. So it's quite far reaching, and the court has large discretion to accept cases, even without any kind of proximity to the forum. On the continent and inside the European Union, jurisdiction rules are more clear-cut. That's not to say that they are not vague. They can be quite vague, but at the outset they are clear-cut, and they delimit jurisdiction of the state courts in a predictable manner. So we don't have a global framework of jurisdiction. We have mostly national frameworks, but we do have regional frameworks such as the Brussels 1 bis system. So inside the European Union, the Brussels 1 regime delimits jurisdiction for all the member states. And inside this jurisdictional framework, the parties may select a forum, choose a forum, so they can agree by contract on which forum is appropriate for their disputes. It's quite important in practice to have these forum selection agreements, and sometimes there is dispute about the outreach of these forum selection agreements. Sometimes the other party says they are void. So you have satellite litigation on the validity of these forum selection clauses, but in principle, it's a very good thing to have an autonomous choice of forum by the parties. So once a court assumes jurisdiction, either on objective rules of jurisdiction or on the basis of forum selection clauses, the applicable law for the substance matter will be determined by separate rules, conflict of laws rules. These are the rules you have been in contact with already, Rome 1, Rome 2, succession regulation, maintenance regulation, and so forth. These are uniform conflict rules. So just as the Brussels regime is a uniform regime for jurisdiction and recognition and enforcement of judgments, Rome 1, Rome 2, and so forth are regional systems to uniformization of conflict of laws rules. But I will not deal with those in particular. Now, having different jurisdictional rules for different jurisdictional systems, it is up to claimant to choose a competent court. A competent court and, of course, a favorable court. And the process of choosing the court best suited to your needs, to the claims you have, is sometimes referred to as forum shopping. And forum shopping has a negative connotation. That's quite clear. So defendants might say, when defending themselves before a forum, well, a claimant has gone forum shopping and the court must decline his jurisdiction. So it's negative. It's a negative thing in that context. But if you look at it from a more objective perspective, it's just something you are in a position to do as a claimant. It's not illegal. If one state offers jurisdiction for a particular case and a second state also offers jurisdiction for this case, what would keep claimant from choosing the more favorable forum? There's nothing wrong with it. It's just, from the international perspective, difficult if you have 2, 3, or 4 forums. And it's even more difficult if you have one forum which attracts very many claimants. And as I said, the US have been for decades such a forum which attracted litigants. Lord Denning once said, like a moth is drawn to the light, the US attracts litigants from all over the world. And of course, he was not very amused by these long arms statutes. But still, I mean, what can you do? What is wrong with having a broad jurisdiction? It's always difficult to pinpoint the problem with it. And it could be sovereignty. It could be, you know, an infringement of the sovereignty of the state where the defendant lives. When the US, in that case, have a very broad jurisdiction, so that without any proximity of the case to the US territorium, you can have an action before the US courts. But it's not very easy to, you know, to argue that there is actually a problem with sovereignty. I won't go into detail. I'm just telling the forum shopping part here, because for protective and provisional measures, forum shopping is quite important, because as we will see, there are very many heads of jurisdiction for these interim injunctions or remedies that might be all over the world. So claimant can choose the appropriate forum, and it's quite complex to assess which is a good forum for you. One aspect is procedural law. So is it, you know, accessible? Is it favorable towards a speedy judgment or whatever? Is it reputed? And the second is, what is the law applicable in substance? So one thing is forum shopping and the other thing is law shopping. So jurisdiction determines the applicable private international law regime, and that in turn determines the applicable law in substance. So you've got options, and you must assess the risk of getting what you want, and then at the end of the day, you will make a decision on which forum to choose. Sometimes you're wrong, of course. And then there is also a cost. Some forums are favorable but expensive, and then, you know, you have to make a decision. Now, sometimes, as I said, defendants raise the forum shopping point as a defense, and they say claimant has gone forum shopping and he shouldn't. And in some countries, in some jurisdictions, mostly common law jurisdictions, there is a defense. There is a name for this defense, and it's called forum non-convenience. So the not so appropriate forum, to put it more in less technical terms. So I just said that in common law jurisdictions, notably in the US, you will have broad heads of jurisdiction. And so the counter effect will be to have a broad exception. Broad jurisdiction, broad exception. So if you can claim for almost anything without any proximity between the case and the territorium of the US, you need a good defense against cases which do not have any connection to the territorium. And this is forum non-convenience. So according to this doctrine, a court can decline its jurisdiction if it thinks that another court in another jurisdiction is better suited to decide on the case, to be a more appropriate forum plus convenience, if you like. And it's quite often that defendants raise this objection, and then, this is at least my impression, the court has a large discretion to decide why another forum would be more convenient. And sometimes, I'll show you an example in a minute, sometimes this goes back to the protection of their own nationals. That's at least something you could be inclined to think when you see the case law. But before I show you the case, the example, just a word on forum non-convenience and the Brussels regime. In the Brussels regime, we do not have this objection. As I said, the Brussels regulation has heads of jurisdiction which are, in theory at least, predictable, and they are clear-cut, and so we don't need a defense against jurisdiction. So it must be clear at the outset where I can be sued, before the court of which country I can be sued. And if this is clear, and I know where I can be sued, I don't need a defense to say, well, there is a more appropriate forum. This is at least what the Court of Justice of the European Union has ruled in Owusu and Jackson, a famous case. It has ruled against the doctrine of forum nonconvenience. So it's no part of EU law. On a side note, I think English lawyers are quite happy, if they are happy about Brexit, but if they are happy, this is partly so because then finally they can get back their forum nonconvenience doctrine and they can plead in court that it's a non-appropriate forum. I don't know how often they plead for forum nonconvenience, but I think it could happen. It's a standard procedure. You try to stop claimant in the thrust of the proceedings, and so you try forum nonconvenience. So this is the case I was telling you about a minute ago. This is a classic case from the US, Piper Aircraft versus Reno from the early 80s, I think. It's a case to show the effect of the forum nonconvenience doctrine. So the background is rather sad. There was a crash somewhere over Scotland. A commercial aircraft crashed in Scotland, several casualties, and they were all Scottish citizens and residents. The plane was manufactured in the US, the propellers also in the US, and the defendant was a US company. So from a European point of view, it's quite clear that you should sue in the US, and that's what they did. And what the court said, a court in California State Court said, well, this is forum nonconvenience, they should rather sue in Scotland. And a basic principle in continental Europe, at least, is you can always sue the defendant at his domicile, where he is residing. And even though the claimants came to the US, to the country where those defendants were situated and domiciled, the court and the Supreme Court then agreed. The court said, this is forum nonconvenience, you should go to Scotland. And this is what I said before. It's probably an attempt to protect US defendants, to favor US companies. So this action, at least this action in the US, is stopped. Doesn't prevent, of course, the claimants from bringing the action before the Scottish courts. I don't know if they did. I could imagine that there was some kind of attempt to settle the whole thing, but at least there is no action in the US. Right, let's move on to the Brussels regulation. And this is the recap part of my lecture. Stop me when it's too boring because you've done that 10 times already. It's just from my experience, it cannot be said often enough. And maybe I'll put it in different words than you've heard already. So maybe there is an effect, a positive effect. Right, but I'll keep it short. So Brussels 1 bis. Maybe the most important regulation in the judicial area in Europe. As I said, dates back to 1968, to the Brussels Convention. Then in 2000, 2001, was transformed into regulation Brussels 1. And then again, there was a recast, and you see the publication here, Brussels 1 bis, and it applies since 2015. The basic point with Brussels is that there must be a connection between the proceedings to which this regulation applies and the territory of the member state. So a link of proximity. That's pretty basic. And the basic link, there is the element of proximity, that's the domicile of the defendant. So you can bring the action at the court of the domicile of the defendant. And this is, it's so basic. I can't repeat it often enough. Claimant is in the driver's seat. The claimant will bring the action and determine the scope of the action and determine the time when the action is being brought within the limits of prescription, of course. But he is the active part. The defendant must wait and see. But he can wait and see until the action is brought at his domicile. That is the basic principle. So it's if you will, a principle of procedural justice. So defendants not domiciled in a member state can be sued, but not under the Brussels regime, save for several exceptions, but in principle cannot be sued under the Brussels regime, but maybe can be sued under the regime of the law of a member state. So just to give you an overview, what I just explained, that's the general rule of jurisdiction, Article 4. So the domicile principle. The Latin maxim is actor sequitur forum rei. So you can sue the defendant at his forum. That's the principle, general rule. There is a definition on natural person and a legal person elsewhere in the regulation. And then there is a special head of jurisdiction, Article 7, or special heads of jurisdiction. There are several, and also in Article 8. There is exclusive jurisdiction, Article 24, 25, and then something in between special and exclusive jurisdiction. I will call it protective jurisdiction, Articles 10 to 23. Protected are consumers, for instance, or labor cases and insurance cases. They've got special treatment. So in these articles, the weaker party, the presumably weaker parties are protected. You cannot sue them anywhere else, usually only at their forum. But outside these consumer and so forth cases, there is, in the first place, exclusive jurisdiction. If you don't have exclusive jurisdiction for your case, you may choose between various heads of special jurisdiction, and if there is no special head of jurisdiction, you can only sue at the domicile of the defendant. In practice, it's quite often not the general rule which applies, but a special head of jurisdiction. So you may say, well, the exception has turned to be the rule. That is true. And that is a problem also. But it's difficult to divert from the general rule to make the special jurisdiction the new rule. So even though in practice it might be vice versa, so exception is rather the rule, the regulation sticks to this ranking. Just a few words as to the special jurisdiction. The most important ones are jurisdiction in contract, Article 7.1, and jurisdiction in tort, Article 7.2. And I'll just briefly deal with it because these jurisdictions also bear consequences on provisional and protective measures. Basic rule is wherever you can bring an action, you can also bring an action for the main cause of action. You can bring an action for provisional and protective matters also. So Article 7.1 brings an exception to the general rule. You may sue somebody domiciled in one member state, in another member state, in matters relating to a contract in the place of performance of the obligation in question. So once you have a contract, there is a new head of jurisdiction wherever the place of performance is. And this rule, I won't go into details, is a bit difficult because you've got these different instances. You've got different types of contracts, and you have a different approach, at least from the point of view of the European Court of Justice, a different approach as to the delimitation of this head of jurisdiction. I won't go into details, it's quite complex, but the bottom line is you have to find out where the place of performance of the obligation is. You can even conclude agreements on the place of performance. In theory, in practice, that's a different matter. The Court of Justice has ruled, in any case, if there is no link at all between the place of performance you have agreed on and the actual contract, then it will not be valid within Article 7.1. The second and also very important head of jurisdiction in Article 7 is the jurisdiction for tort claims. So again, you might sue somebody in another member state than the member state of the domicile in matters relating to tort, delict, or quasi-delict. So that's a difficult concept, but the idea of the regulation is to include anything that might fall into the scope of the broad category of tort or delict, because tort is an English notion, delict is a continental notion, quasi-delict is something in between. So anything is included, wrongful action. And here you may sue in the courts for the place where the harmful event occurred or may occur. So the place where the wrongful event took place is also a place of jurisdiction. And this is quite important for provisional measures, because where the harm may occur, we don't know, but where the harm may occur, there will be jurisdiction. So it's a principle of ubiquity. It could be anywhere in Europe or anywhere in the world, indeed, and anywhere where the harm may occur in the future, there is also a jurisdiction. So this is quite broad. You may remember what I said before. I said the heads of jurisdiction in the Brussels regime are quite clear-cut, foreseeable, but this is, let's face it, not foreseeable. So you can claim that the harm will occur, may occur at this and that place. You bring an action, and then, of course, you have to prove that there is a certain likelihood that this may happen, but you can bring the action. And this is sometimes the important thing. Not that you win, but that you bring the action. So in the jurisdiction of the European Court of Justice, this place where the harmful event occurred or may occur can be understood in a double way. One could be to understand it in a way that it is meant to be the place where the harmful event giving rise to the damage occurred. And second, it could be the place where the actual damage occurred or may occur. So the place where the action took place and the place where the result then occurred. And the Court of Justice, in a rather Solomonic way, said, well, it's both. We can't really infer from the wording of Article 7.2 that it's either of it. So it's probably both, because if you look at the regulation, what lies behind this head of jurisdiction, Article 7.2, it's the protection of the victim or potential victim. And how do we protect the victim better than by giving him or her a double head of jurisdiction? So it's for the victim, for the claimant, to choose between either of these places. And this gives rise to some problems when you have multiple places where this wrongful event could have taken place or the result could have been inflicted. We are talking about multi-state delicts, and again, it's quite pertinent for our topic, because for something which will occur, may occur in the future, you've got, a way of arguing, well, this is something where the harm may occur. And it's quite often the case in libel cases, libel and slander, personality rights, infringement of personality rights, and mostly these delicts or torts occur in the internet these days, social media, hate speech, and so forth. So these are torts, and there might be liability, or you might refrain the other party from stating such phrases, and you want to sue. And the question is, where can you sue? Where does the damage occur in cases where you communicate over Twitter or whatever social media that may be, that the other party is whatever? Now, basing your claim on the principle of ubiquity, the harm resulting from that kind of libel may occur all over the world. So Twitter is accessible in most of the world these days, and anywhere somebody would read this and think of, okay, that's interesting, that's a libel, but it might be in all parts of the world that the result of this wrongful event takes place. So could I then sue for damages or whatever in all parts of the world? Because the harm inflicted is really in all parts of the world. And the Court of Justice had to deal with such a case before the internet era in the Shebel case. It was a case relating to a newspaper libel case. And the court was asked, well, is it really that the claimant can sue in all member states? Because this magazine or whatever that was in the Shebel case was accessible in most of the member states. And the court said, well, yes, it is a ubiquitous liability, but you can only sue for the damage sustained in the forum state and not the worldwide damage. So you can sue wherever you want, provided that there was some damage or that there may be some damage, but you cannot sue for the entire damage in that jurisdiction, but only for the proportionate damage which was inflicted in that particular jurisdiction. And this approach can be called mosaic principle, because when you look at it, really, you have to sue in different jurisdictions, and in each jurisdiction, you get only a fraction of the damage. So you have to sue 3, 4, 5, 10 times to get the entire damage. So it's really totally impracticable. You cannot, take this seriously, this approach. So what you will do is you sue at the place where the action took place, not where the damage was sustained. For internet-related torts, the Court of Justice realized the limits of this approach, because what was feasible, at least in theory, with newspapers, where you can say, well, in this country, 5,000 copies were sold, in the other one, 10,000. So you can build fractions with respect to the entire number of the newspapers sold on that particular day or week, but you cannot do that with internet-related torts. So it's virtually impossible to build fractions of damage in one country as related to the entire damage. And this is why the Court of Justice in the eDate case said, well, in internet cases, we have a different approach. We will have jurisdiction at the center of the victim's interest. So where the most of the harm was done. And in that jurisdiction, we will allow claims for the entire damage. And this is quite favorable for the victims, because where would that be? It would mostly be at the domicile of the victim. So they can sue at home, if you will. Right. So we'll come back to Article 7.2. when we speak about the provisional measures, because as I said, it's quite prone to these aspects that you have provisional or apply for provisional measures when you see them as torts. So it's quite common to have a jurisdiction under Article 7.2. Very briefly, Article 24, exclusive jurisdiction. When there is exclusive jurisdiction, the other forums are not viable. You cannot go to a special head of jurisdiction and bring your claim there. You have to be at the exclusive jurisdiction and bring your action there. If you look at Article 24, you see that the connection between the case and the forum is always so strong that there is no other option than to bring the claim before this court. So, for instance, claims concerning immovable property, the connection between a piece of land and the courts, the local courts, is so strong that you wouldn't want to bring an action elsewhere. Same with the enforcement of a judgment. Enforcement is something done by public authority. So the local courts should decide upon the enforcement and the legality of a enforcement of a judgment. Same with registers. When you sue because you think a company was wrongly deleted from the company register, you bring your claim at the local court and only there. The next exclusive jurisdiction is the choice of forum, Article 25. And this is something I referred to already. Article 25 reflects the principle of party autonomy. So the parties, by mutual agreement, can select a forum. And Article 25 is quite open to these forum selection clauses. You may even select a forum inside the European Union if neither of the contracting parties is domiciled in a member state. So a US citizen and a Japanese citizen can choose the High Court in Dublin as the competent forum. That would be possible. For provisional and protective measures, it's of indirect relevance, so you can bring an action at the court of choice, also for your provisional measures. But you will rarely find examples where the parties conclude a choice of forum agreement as to provisional measures. That would be surprising. Right, moving on to lease pendants and related actions. So now we have established jurisdiction, the proceedings is up and running, and then one of the parties decides to bring a second action, parallel action. And of course, this is something which shouldn't happen. We shouldn't have two parallel actions. This is something to be avoided. We want one judgment for one cause of action, and we do not want to run the risk of having two irreconcilable judgments from two different courts. So the basic principles applied by the Brussels regulation is the principle of priority, and it's a principle of temporal priority. So the first action brought is the action that goes forward, and any later action will have to be ceased until the jurisdiction of the first court is established. But the first court will determine whether or not it's competent. If it's competent, the second action will be stopped. And if it's not competent, then the other court can go forward. Very simple and efficient. The problem is there might be conflicts with choice of courts agreement. And there have been these cases in the past. So somebody has concluded a choice of court agreement for a selection clause with the contracting partner, but the other party brings an action elsewhere, not at the court the parties have agreed on. And let's assume that this action is brought in bad faith. So to prevent a real action, the action at the proper court to go forward. And these actions are sometimes called torpedo actions. So to the torpedo as a symbol for hindering, for hampering an action to go forward, to destroying the proper jurisdiction. And it was an efficient method in at least in some jurisdictions to do just that. You bring an action to the extent that is possible under the local law, and you claim a declaration of the court that you are not liable. So if you wait for the other party to bring an action for liability, you bring a negative declaratory action, I am not liable. And you bring it at a court in a jurisdictional system where you know that that is very slow. And the second court, the court which is competent by a forum selection clause, has to wait until the first court has decided upon its own jurisdiction, which can take ages. So the whole thing comes to a standstill. This is called torpedo action, and it was apparently a bit of a problem. For instance, in patent litigation, it was quite frequent to bring torpedo actions in the context of patent litigation. Now, the Brussels 1 bis regulation has a solution to this problem, at least for those contracts with a forum selection clause. And the solution is to invert the temporal priority for cases where there is a forum selection clause, to say that the court which is selected by the parties is always the court which declares on its own jurisdiction. So you can always bring an action at the court which has been selected by the parties, and the temporal priority is being inverted. Now, question, can you use this regulation, this torpedo scheme, in the context of provisional measures? So can you bring an action for provisional or protective measures with the only goal to stop the main proceedings? Is that possible? As I said, there are many heads of jurisdiction for provisional actions. So you could use any of these jurisdictions to bring an action, and you bring it fast. And it's easy to bring it fast because provisional measures, they are provisional and temporal. So it's not important to have evidence so much. Can you stop the main action by way of bringing an action for provisional measures? I don't know if some of you are practicing already. Have you ever thought of doing that? The idea is fine, of course, but there is one major problem with it. Why this probably wouldn't work, would never work. And it relates to the nature of lease pendens, of parallel actions. And I said the main goal of this lease pendens rule, of the priority principle, is to prevent irreconcilable judgments. But judgments are only irreconcilable if they have the same cause of action. And provisional measures and the main actions never have the same cause of action. They're different causes of action. So they can never stop the main action to go forward. They're just separate. So it's not a good tactic to have a provisional or an injunction or an action for provisional application for provisional measure with the intent to stop the main action. A special type of action, interim action or provisional action, is the so-called anti-suit injunction, measure against foreign proceedings. It's an injunction restraining a claimant from pursuing foreign proceedings. And in the context of these torpedo actions, sometimes anti-suit injunctions have been tried to stop the torpedo from going forward. So assume somebody brings such a torpedo action to bring main proceedings to a standstill. Can you apply at your court, the competent court, to issue an anti-suit injunction to order the other party to take back the torpedo action? Is that possible? And again, this is an idea of the common law. In the common law world, anti-suit injunctions are, I wouldn't say quite common, but they are possible and they root in the common law. So you can grant such an injunction restraining a claimant from pursuing foreign proceedings if to carry on those proceedings would mean great injustice to the defendant. Again, you see there is a good deal of discretion with the court. What is great injustice that shouldn't be done to the defendant? There is discretion, and the exercise of this discretion can lead to granting such an order, and then you can tell the claimant either not to bring this action at all or to stop proceedings at the foreign court. Now, again, inside the European judicial area, such anti-suit injunctions are not possible. They're not possible, says the Court of Justice. That's the case Stuerner and Grobet. It's not possible because it would interfere with the Brussels system, the system of precise jurisdictions, heads of jurisdiction, and with the goal of having predictability inside the system. And one court would be, assuming the task of the other court, that is to tell whether or not this court is competent. So there is only one court to say I'm competent, and that is the court seized. And it's impossible for any other court to say to decide on the competence of another court. A court can only decide on its own competence. So an anti-suit injunction is incompatible with the Brussels system. Lastly, recognition of foreign decisions. This is an important part of the Brussels regime. I told you about that already a minute ago. There is a basic principle of automatic recognition of foreign judgments. So any judgment from any court of any member state will be recognized and enforced in any other member state. It's quite comfortable to know that there are 27 potential enforcement states when you have a judgment of one member state. Recognition and enforcement may only be refused if one of the grounds of refusal under Article 45 of the Brussels regulation are being satisfied, one of them being public policy of the forum state. So whenever there is a violation of public policy of the forum state, you can refuse to recognize and refuse to enforce. It's quite rare. Right. Moving on with a specific eye on provisional and protective measures. Now, we have seen heads of jurisdiction, we have seen lease pendants, we have seen recognition and enforcement. Where are provisional and protective measures? In the Brussels regime, there are two rules on provisional and protective measures. One is a very common one, Article 2, and the second is a specific one. It's a separate chapter in the regulation, but it doesn't contain any very precise rules. So the first reference to provisional and protective measures is made in Article 2. Article 2 contains many definitions, and one of the definitions is dedicated to decisions, and a decision under Article 2 of the Brussels 1 bis regulation encompasses provisional and protective measures. This is just to make things very clear. A decision includes a provisional and protective measure that has been issued by a court. So they fall flatly within the framework of Brussels 1 bis. Then Article 35 provides a few guidelines as to the treatment of provisional and protective measures, and it reads, application may be made to the courts of a member state for such provisional, including protective measures, as may be available under the law of that member state, even if the courts of another member state have jurisdiction as to the substance of the matter. It's not self-evident what is written here, I would say. The regulation doesn't contain a fully fledged system of jurisdiction and recognition for these measures, but tries to integrate them into the system of the Brussels regime. So from Article 35, two things can be inferred. One, provisional and protective measures may be applied for before any court competent under the Brussels 1 bis regulation. And this is why I explained the heads of jurisdiction in some detail. So wherever you can bring an action under Brussels 1 bis, you can bring an action or an application for provisional and protective measures. That's one. So the Brussels regime is open to these applications. Second, and this is really what is meant by Article 35, such applications may also be applied or may be made under any jurisdiction there might exist under the national law of the member state. So if a member state has more heads of jurisdiction for provisional and protective measures, you're welcome to use them. So there is a proliferation of these heads of jurisdiction for provisional and protective measures. There is no exclusivity of the Brussels regime. You can use all heads of jurisdiction. There is only one restriction, and this comes from the case law of the Court of Justice. If you use a head of jurisdiction of a member state's law, there must be a real and substantive connection between the claim and that member state. This is to prevent actions going forward with no connection at all between the member state and the cause of action. It is to prevent member states from providing heads of jurisdiction exclusively made for the protection of their own nationals. So you must prove that there is a real and substantive connection between your claim and the territory of the court seized. Real and substantive connection is, of course, open to interpretation. And of course, this is something you could argue before a court. There is a connection. And is it real and substantial or substantive? This lies, of course, in the discretion of the court. So Article 35 opens the Brussels regime to more heads of jurisdiction, to whatever tradition a member state might have or openness might have towards these applications for provisional and protective measures. There is not much case law on these provisional and protective measures, at least not by the Court of Justice. So Article 35 has been a very quiet article in the regulation. I want to discuss a little more in detail a very recent decision from 6 October 2021, a case called Toto. And it's roughly what happened. You find it here. We had a contractor from Poland who concluded a contract with a public authority in Poland. And the content of the contract was the contractor had to build a section of an expressway in Poland. Now, this was a large-scale contract, and the Polish authority wanted a guarantee for the obligation to be fulfilled. So what the contractor did was go to a Bulgarian insurer and ask him to provide this guarantee. The Polish contractor, Bulgarian insurer, and this is, of course, the cross-border setting. Now, the contract wasn't properly performed. This is at least the view of the Polish authority. And so they made use of the guarantee. They approached the Bulgarian insurer and said, well, you know, the highway isn't built yet, please pay. The contractor said, well, no, we did everything according to our agreement, and it's bad for the reputation, for our reputation, if this guarantee is being invoked. And they wanted to stop the Polish authority from approaching the Bulgarian insurer with a view to the guarantee. They applied to a Polish court for a provisional measure, preventing the authority from asking the Bulgarian insurer for having the guarantee fulfilled. They were unsuccessful, and so they tried again, and this time in Bulgaria. So they made a similar application to the Bulgarian courts. Now, from the facts of the case, it's not quite clear whether before the Polish courts, proceedings were still pending or not. That's not quite clear. So it could be either the case that before the Polish courts, there are still proceedings pending in that matter, or it could be that proceedings were brought to an end before the Polish courts, and now the Bulgarian courts had to decide, can we go forward? Can we grant the application, or are we kept from doing that for any particular reason? And of course, it all hinges on the question whether this is a lis pendens or res judicata issue here. The court, unfortunately, did not clarify that. So he was asked by the Bulgarian court to decide whether or not there was jurisdiction in the case. And the question was, is a Bulgarian court not having jurisdiction as to the substance of the matter precluded from issuing provisional or protective measures under Article 35 in a situation where a Polish court having jurisdiction as to the substance of the matter has already given a ruling on an application for identical provisional protective measures and rejected the application. So this is the res judicata perspective, but from the facts, as I said, it's unclear if this is really the case. The court wasn't very precise on that. So the court answered in a very sketchy way, I would say, and he answered that the Bulgarian court is not obliged to declare itself incompetent to decide because there is no hierarchy between the court having jurisdiction as to the substance of the matter and any other court having jurisdiction to issue interim measures, in brackets, under their own national law. So provided Bulgarian law confers jurisdiction on the court to issue such provisional measures, there is nothing to keep the court from doing so, at least not in the Brussels regulation. As I said, Article 35 opens the Brussels regime to national heads of jurisdiction, and this is precisely what the court stated. It did not state, however, whether the lis pendens situation or res judicata situation was pertinent in the case. So one would think, if this is the same subject matter in the second case, the second court will be prevented from deciding in the case. So it's really a question whether or not this is the same course of action. And it doesn't transpire from the judgment or from the facts of the case whether or not this is the case. One would think that if it is the same course of action, one cannot possibly allow the second court to go forward with the case, because allowing the second court to go forward would mean to give the claimant a second bite at the cherry, so to put it, and what would prevent the claimant to go to the third or fourth court if they fail with their previous applications. So this is not what we want in the European judicial area, but unfortunately the court did not really pronounce itself on that matter. So as I said, once we have such a measure, such an injunction, there is recognition and enforcement because Article 2, letter A of the regulation includes such measures in the framework of the Brussels regulation. There is automatic recognition. There is one precondition, however. If you have provisional and protective measures, which were granted ex parte, that means without the defendant being present in the proceedings, the right to be heard of the defendant has been infringed. And the definition in Article 2, letter A of the Brussels regulation clearly states that such injunctions cannot be recognized. It reads, judgment includes provisional and protective measures ordered by a court or tribunal, which by virtue of this regulation has jurisdiction as to the substance of the matter. It does not include a provisional including protective measure, which is ordered by such a court or tribunal without the defendant being summoned to appear, unless the judgment containing the measure is served on the defendant prior to enforcement. Now, the regulation tries to strike a balance between the procedural rights of two parties. One, the right of the claimant to have a judgment, an injunction, to safeguard the substantive rights, and the other to safeguard the procedural rights of the defendant to be heard. So for a claimant getting such an injunction, being granted such an injunction, that is a dilemma. Either you serve this injunction on the defendant to enter into the scope of application of Brussels 1 bis with respect to the recognition and enforcement of the injunction. If you do that, then of course there will be automatic recognition, but the defendant will have knowledge of this injunction and might want to, stash away the assets somewhere you can find them. Or you don't do it. You don't serve the injunction on the defendant, but then you will not have any cross-border effect. So for the practice, this is quite difficult. To sum up, ex parte proceedings do not produce any effects outside the respective territory of the state where the injunction was issued. Now, this was a major downside, of course, for the Brussels regime, and this is one of the reasons why the account preservation order regulation was set up. You see, it's relatively recent, 2014, entered into force in January 2017. And the goal was to fill a gap that was seen between the judicial, the idea of a judicial area and effective enforcement, cross-border enforcement on the one hand, and the Brussels regime, where exactly this was not possible. And the 27 or at that time 28 different regimes in the member states with regard to the freezing of assets. So the regulation was devised and put into force January 2017, and it's not meant to substitute any other regime the member states might have. So it's optional. You may choose if you like. And you can say there is a competition between the models, the European model and the national models. You can use whichever you like. And of course, the regulation has some advantages. But as I said, at least in Germany, I don't know much about the other systems. I guess it's not much better there. Hardly ever is this regulation being used? In 2020, that's the latest statistics I could get hold of in Germany, there were 129 applications only in entire Germany for the entire year. That's 0.05% of more than 2 million cases dealt with before those courts only. So there are much more, of course, in Germany, but these are applications for enforcement. So it's marginal, it's virtually inexistent. Why would that be? First, a brief look at jurisdiction. The regulation does not contain any special heads of jurisdiction. It just states that the jurisdiction is connected to jurisdiction on the substance of the matter. So that's the basic rule. Wherever there is jurisdiction for the substance of the matter, there is also jurisdiction to apply for an account preservation order. There is a special rule for consumers, not interesting in this context. And there is also a special rule on situations where you have already obtained a judgment. But in principle, nothing new. There is jurisdiction according to Brussels 1 bis, and the account preservation regulation just follows this pattern. Article 7 is vital. It states the conditions for issuing such a preservation order. And from the wording, you see how generous this regulation is. It states the court shall issue the preservation order when the creditor has submitted sufficient evidence to satisfy the court that there is an urgent need for protective measure in the form of a preservation order. Because there is a real risk that without such measure, the subsequent enforcement of the creditor's claim against the debtor will be impeded or made substantially more difficult. This all is discretion. So the court must decide if there is sufficient evidence. It must not be compelling. It must just be sufficient. It must be an urgent need for this order, and it must be decided whether or not this enforcement is really in danger or, just substantially more difficult. So discretion of the court, and maybe this is one of the reasons why this is not being used. Maybe claimants are not really happy with it because they think this is too large a discretion. We want to have stricter rules. This is not predictable. We have no idea whether or not this will be a successful application. And they rather resort to the instruments available under domestic law. This is at least one explanation. The regulation also contains a rule on evidence. The court shall take its decision by means of a written procedure on the basis of the information and evidence provided by the creditor. So the evidence, which must only be substantial evidence, sufficient evidence, comes only in written form and only from the creditor, claimant. The court can request the creditor to provide additional documentary evidence, but there are no witnesses, just evidence. Only in exceptional cases, the court may use another appropriate method of taking evidence available under its national law, such as oral hearing or witness. Of course, this all must be quick. So you cannot have a full hearing, you cannot have an expert or things like that. It must be quick, and the court must decide on the basis of paper preferably, and only in exceptional cases have witnesses. There is no separate method of taking of evidence. As you see, the regulation refers to national law. So it's all up to the law of the member states. And now you see the progress that has been made with respect to Brussels 1 bis. Usually, these proceedings are ex parte proceedings. That means the debtor shall not be notified. And of course, the effect is clear once the debtor or defendant is being notified. The debtor, of course, will know something is, happening, and he can take action to prevent the claimant from being successful. So it's ex parte really, and this is the standard proceedings. The novelty, however, is Article 21. Such an order issued in a member state in accordance with this regulation shall be recognized in the other member states without any special procedure being required, and shall be enforceable in the other member states without the need of a declaration of enforceability. So exactly what is not possible under Brussels 1 bis, having an ex parte proceedings and have full recognition in all the member states, is being granted by Article 22. This is, for the claimant, this is great. You have an ex parte proceedings, it's a very swift proceedings, and you have full recognition in all member states. But as I said, nobody uses it. Moving on to the last slide, I promised to say a few words on evidence. I did all the time really, but just to make things very clear, there is no European regime on the taking of evidence. There is no uniform regime. What we have is a situation where the law of civil procedure is domestic law. So the law of Cyprus would decide in proceedings before the Cyprus courts on how you would take evidence. However, when you have cross-border taking of evidence, you will have to resort to different regimes. So you will have such rules in your national law, of course, but as taking of evidence, hearing of witnesses and so forth, with cross-border implication, bears on the sovereignty of the state concerned. So if the witness is for instance, in Greece, you cannot just question the witness if you are a court on Cyprus, but you have to ask the Greek authorities, may we question this witness? Or could you please question the witness for us? Both is possible. So it's quite cumbersome. Inside the European Union, there is a regulatory framework, namely the Evidence Convention. It was recast recently and will enter into force on July 1st, and it provides a framework for the taking of evidence abroad. However, even inside Europe, it doesn't allow for a direct taking of evidence. So the court in Cyprus cannot, under this framework of the evidence regulation, ask a witness to contribute to the proceedings without asking first the Greek authorities, may we question this witness? There must be a formal request, and then if this request is positive, answered positively, then the court can have a video interview, for instance, questioning the witness. But it cannot do so of its own motion. It must ask the Greek authorities before. So there is a framework for cross-border taking of evidence in Europe, but it's only really a matter of cooperation. It doesn't contain substantive rules on evidence. It just refers to the member states' law when it comes to the probative value, for instance, for witness or documents. That's all for the member states. So the only goal is to facilitate the cross-border taking of evidence, and the rest is up to the member states. Right. That's all from my side for the moment, and I'm happy to take questions.
Thank you so much, Michael. Right, so I would like to ask our participants if they have any questions that they would like to ask.
And I know it's difficult. I have been talking so much, and I'm happy to take questions via email later on. If you like to refer to them in written form, send me an email. Professor Lombardi knows my email. You can write to him and he'll forward them to me, or you'll find my email on the internet, and I'm happy to answer them if I can.
Absolutely, thank you. So let's see if anyone writes in the chat. I do not see anyone typing anything.
That's absolutely fine. I can understand.
Yeah, I think my question would be, you have already mentioned that Paul, it's not widely used, but do you think it will be used more in the future, or are we basically going to stay stagnant? Because as far as I know, it is, at least in Cyprus, not many people were actually aware of it.
Yeah, exactly.
So I don't. Personally, I don't see it gaining momentum anytime soon, but maybe now that we have more of a development in the financial environment, there could be some development, but I would like to hear your thoughts on that.
That's a difficult one. I don't know really. I mean, what this account preservation regulation provides for is a pretty straightforward regime. I mean, you don't have to prove much, you don't need much evidence, you just apply for it, and you get a title, freezing assets inside the union. So it's pretty good. In Germany, in the first year, 2017, I think there were 300 applications. Next year, 200, and then 129. So it's a steady decline. And I'm not sure why that is. It could have to do with the practice of the German courts. I would have to inquire how things are in the rest of Europe. But it's strange. Otherwise, you would expect that numbers go up. So in the first year, nobody knows it and nobody uses it. And at some point, you get familiar with it and you use it. But no, the other way around. But there are other examples where you have, regulations which are made use of only sparsely. So the European Enforcement Order from 2004, that's also something, which doesn't work. Even though it's not bad, you get an executory title in uncontested claims, and that happens quite often. So you get judgment, default judgment, and you can just apply to the court for an enforcement order. But nobody uses it. And the question is, do you update it? Is it just not comfortable enough? Do we need more? Do we need a better version? Or do we abolish it at some point? And in the case of the enforcement order, the idea was to include it in the Brussels regime and to upgrade the entire system. It only worked out partially. The same could happen with the account preservation regulation. I could imagine that the next recast version of Brussels 1 bis could include the account preservation regulation and enlarge its scope to make it more known. Because as you say, I think that's quite common. We've got a dozen at least of regulations inside the judicial area, and it's only known to specialists. So if you're a specialist on European law, you know how they work, these regulations, you can really benefit. But a normal lawyer who will have very few cross-border cases will not know these regulations and will not use them. However, if you have a Brussels regulation, which is, I think, well known or relatively well known, then you will be maybe aware of the freezing injunction that is inside this framework, but not if it's a separate regulation. This is a kind of explanation I can offer.
Thank you. And I think perhaps one of the reasons why they have declined maybe is because people start moving assets elsewhere apart from only the European Union.
Possible. Yeah.
Which is another very reasonable explanation.
Exactly.
I don't know if anyone else has any other questions. I cannot see anything in the chat from our side. So on that note, I would like to thank you so much for giving this guest lecture, and it has been a pleasure to have you.
Thank you so much.
I'm sure the students have also benefited, and also the practitioners here. Thank you so much.
Thank you. Have a nice afternoon. And as I said, you can contact me via email if you have further questions. Thank you. Have a nice afternoon.
You too. Thank you so much.
Bye.